a request video on trying to figure out how laws work. Now, if you're not aware of it, me being able to rip apart how a program works, fair to middle inability, by the way, and or my ability to decode complex word salad comes in handy when looking at laws. Offenses against public health, safety, and morals, Texas Penal Code, Title 10, Chapter 46, on weapons. Subsection on prohibited weapons, Section 4605. It is an offense under the section, and as a felony, it is a felony in the third degree, and it is an offense as a state jail felony if a person does any of the following things intentionally, knowingly: possession, transport, repair, sale, or manufacturing. Now I'm going to decode this pretty quickly. The act of making something is different than manufacturing. The legal system has decided over many, many, many cases that if you say you're talking about an item, an object, and you use the word manufacture, and it's something commonly able to be sold, that's very important, for the purpose of making and selling it to make money rather than making and using it for some other purpose. If I make a hammer and then I intend to drive a bunch of nails, that's not manufacturing. I made a hammer so I can drive some nails. If I manufacture a hammer, it can be subject to regulations because I have to do a decent job making it. I can't make really crap. It's a bunch of rules. But if I make something for personal use, it doesn't have as many rules. It's also based on the idea that most regulations and rules are about things you buy and sell. This is where sovereign citizens will have a conniption and scream, that's how all law is based. No, it's not. Period. But because they didn't use the word make, are you allowed to make something? Well, it says you can't possess, you can't transport, you can't repair, you can't sell, and you can't manufacture, but possession of the item. The only exception here is if you were to make something but not complete it and someone stole it, therefore they're transporting it, they're in possession of it, and then they finish it, so they've repaired it, and then they sell it, or they get claimed to be the manufacturer because they completed the process and maybe they had no intention of keeping it. Prosecuting you can't work. This has actually been used as a positive defense before conviction. Positive defenses are things you do after you're found guilty. This was done beforehand by yelling, basically interrupting a court case and saying, it was stolen from me, I hadn't completed it, it wasn't a completed item, and it was actually the California zip gun law. And the case was tossed out because, number one, they were really pushing it. It was someone assembling a gun from only one part they had made. The rest of them were parts they bought, so it wasn't a zip gun. But the part they made was basically a buttstock as an extension tube done with something that wasn't a gun part. In the state of California, at one point, you were allowed to make a gun, not manufacture, make a gun, from parts that were all intended to be gun parts in the first place. And the reason is, their gun laws, like most gun laws, if they mention the word zip gun, is stuff that was never intended to be a gun for the fact that, number one, it's cheap and easy to get. Number two, your quality control isn't going to be good enough for a gun. And number three, they just want to exclude guns that are poorly made that way. Because at one time, if you're not aware of it, actually in every city at one time or another, but at one point in the United States, making guns that would blow up in your face was a very common problem. People would then resell them, make them en masse. Unless you're in the middle of an insurgency situation or you're being invaded by another country, making sketchy guns is looked down upon by the legal system because it's an unnecessary danger to yourself and the public, because a gun can throw a bullet a mile downrange. I mean, you might be aiming here and it might hit over here and hit some innocent bystander when you're actually aiming at the target. So there is a kind of rationale to it. Any restriction on guns is a violation of my rights under the Constitution. No, it's not, because it's about weapons. Again, keep and bear arms. Arms is implied, but not exclusive to guns. And at the time, especially, it was anything that was a weapon. I don't care if you like that. I've already gone down this road a couple of times. No, it's not a right to a gun. It's a right to arms, which is any weapon. You have a right to have access to any, as in any kind of weapon you can get your hands on, but they can restrict individual types. And I don't give a fuck if you like it. You have a right to defend yourself and defend your country. Specifically, it was about defending your country, specifically against England. It is not a right to a specific weapon. I want to have a mace covered with cyanide. No. Why? Because you're an idiot. Get something good. Okay. And I don't care if you like that. No, you misinterpreting the law doesn't make it a law that's different. And again, I'm not giving legal advice. I'm trying to wade through this. Specifically about zip guns, their definition. But again, the restrictions here mostly are about don't make, instead of zip gun, it should be poorly made guns. Some states have a rule where you can make anything you want to, but you have to have a gun shop, specifically a gunsmith, test the thing under safe conditions. I've actually been a person doing that work at one time. I was testing ammo that was reloaded at the time, and sometimes a barrel. I worked that way, for a little while to make some money. A zip gun, in the definition, inside of Texas, a device or combination of devices not originally made as a firearm, not originally intended to be a firearm, variations of these words, or firearm part. They're not including the word part, but that I'm stealing that from California law. Things adapted to expel a projectile using energy generated by an explosion or burning substance or propellant through the smooth or rifled barrel bore. A smooth or rifled bore doesn't make a difference if a device or combination of devices were not originally a firearm or part of a firearm. The case in California was basically a buffer tube buttstock combination put onto an AR. Somebody wanted to make a court case of it. But because he was literally putting it together and not finishing it and didn't have the rest of the stuff in, and someone sold the thing and was caught with it, he got blamed for it when, first of all, they couldn't prove he's the one who did it. Number two, he hadn't finished doing it. Number three, he wasn't in possession of it anymore in the state where it would be illegal, the physical state. He hadn't manufactured it for redistribution. He hadn't transported it. Someone stole it. He hadn't repaired it. The other guy did, and did a poor job probably. And he hadn't sold it. Almost identical wording in law. So again, you have a right to keep and bear arms, but that doesn't necessarily require that we accept that you have a right to keep and bear firearms. This shall not be infringed about arming yourself, not about guns. I don't like that. I don't fucking care. And that's the way the legal system treated it for decades until a rule came through that said, by nature of the following new change. No, this isn't founding father argument. This isn't a Reagan appointee. It was a decision that they made that said restricting people from arming themselves for firearms is a violation because, and this is the thing, it's the most practical way to do so for defending oneself personally and for the country. Fighting an invasion force from China or Russia with pikes, rocks, slings, throwing stars, potato cannons. The most practical one would be firearms. Not that that was the way it was back then. It was, but not really. Cannons were more effective. They were. But now, what's more effective than a cannon these days? A bunch of people firing rifles accurately. A firearm is now considered, because of changes in society. No, it's not ancient rules. And they decided the Second Amendment should apply to firearms. And specifically the wording was, why should it only not apply to firearms? That was the actual argument. It has nothing to do with the arguments you see on the internet. I don't care what you say. So let's move on. What are the exclusions about this law? Unless the item in question is otherwise not subject to regulations and requirements of the following. The U.S. Department of Justice deciding that it has to be regulated and be on a list as a curio or replica or an antique manufactured or designed before the year 1900. As long as it doesn't use rimfire or centerfire ammunition that's commonly available. And the Department of Justice has put it on their antique, curio, and relic list, or it's a replica of one. That's it. If it uses 22 caliber rimfire, no. But if it uses 35 caliber rimfire Magnum, which is really, I just made that up. I don't think it exists. But if it's a 357 rimfire cartridge, which there isn't any of, but there were back then. There really were. That's not regulated because it's not commonly available ammunition. You're using it very, very limited purpose. It's not going to be something that's going to be used in a firefight unless needed, but it would be on the U.S. DOJ list of approved by federal ruling. Texas would have to follow the federal law that says if somebody got this and it's on the list or it's a replica of it, you're not allowed to regulate it. You can't call it a zip gun. You can't call it an illegal firearm. That includes things that are overbore or even smoothbore that would normally be illegal. The other exception is if it has a registration or followed the requirements of the ATF because they registered it. In the state of Texas, you can't go after somebody by calling it a zip gun or any other argument if the ATF approved it because you paid your fucking tax for it. Now again, most laws are really done under the guise of being regulating commerce or taxes. This is a literal reference to a tax. If you paid your federal tax, that gives you carte blanche in most states to own even a machine gun. In fact, the other things listed besides zip gun are that. And yes, I'm saying that you can get the ATF to approve you going out of your way. Yes, I filed the paperwork. They just, it was a request for information. They haven't responded. But you're allowed to make, an ATF-approved $200 weird gun for test purposes and say, I would like to pay the $200 tax stamp, or you give me a tax stamp that says $5, but I don't have to really pay it. They actually do that for building something weird that would be considered a zip gun. It's an administrative ruling that says you're allowed to build it. You have to do that before you build something weird that would require a $200 tax stamp. And sometimes they waive the tax, but they demand that you ask them first. And you have to give up all your data, but the ATF says, here's your registration and notification through them or the DOJ that says you're allowed to build this. And it'd be considered a zip gun, except they said you can build it. If the federal government, specifically the ATF or the DOJ, says in Texas you're allowed to build something that would be considered a zip gun, you can. And here's why. It's a defense prosecution or prevention of it if the actor, you, did this conduct as incidental to the activity of a police officer, correctional facility place, or whatever. Why? Because you're getting the ATF to approve, or you had your boss approve of you making basically a zip gun to show prison guards what a zip gun looks like. Sometimes they don't have them. You might need an example of it. Or you were dealing with them as an antique or curio. Yes, there are things that would be considered zip guns that are just simply things that were made before 1900 that were really shoddy looking, that were built specifically because that was what was available. If you're working at a museum, you might see a gun that's literally made out of water pipe. Solely the purpose of making an item, it says making, available to an approved organization, agency, or institution. You might be making one specifically for the purpose of making something from fallout. It would be considered absolutely a zip gun, but you're making it specifically because they get permission from the state to do it. So what does this narrow down to? A zip gun in the state of Texas is anything that started off not being actual gun parts that you're putting together, not being majority of parts that were gun parts, but the majority, or if they want to push it, any part of it that was never intended to be a gun, and you put it on. They can be really pissy about it and say anything you put on there that isn't designed specifically for firearms, you can't have it on for the following reasons. One, they can get away with putting you in jail for it. Okay, fine. Two, because it might blow up, because it might make the bullet go the wrong way, because it might hurt somebody downrange when you're aiming at a target and it goes off skew-wide because you made a bad barrel. Those are the rational, reasonable explanations for it. But the other one is that they want the option of doing this because in the 1960s and 70s, they had a big problem with people making firearms that would sometimes blow up in their hand or hit somebody else or whatever, made out of literally aerial antennas from a car. Okay? They made a set of rules about it. Do I believe that this is a restriction or infringement? No. Because if you're going to make up that kind of argument, stay on topic and actually quote it correctly. But otherwise, basically, if the ATF or the DOJ says you can have it or own it or build it in the first place, they can't touch you. Other than that, you're not supposed to build low-grade, crappy things that might blow up. However, again, you can also contact the Texas DOJ, their version of it, and get permission from them. They've done that. Thanks for watching. Have a good day. Good luck with it.